Hello friends, welcome once again. Let's take our next Supreme Court landmark judgment into consideration. This is one of my favorite landmark judgments. Very various reasons for why I love discussing and reading this judgment over and over again. Apart from the issues considered, it is also one of the shortest landmark judgments given out by our Supreme Court. Those of you who have visited the Supreme Court Museum in Delhi, I keep talking about it, and it is really a nice place to go. And you will see the original judgment in the Keshwananda Bharti case. It is placed there, the original judgment with the signatures of all the 13 judges who wrote opinions over there. In that particular, when you look at that particular judgment, you will see that it is as big as a book on constitutional law. But then Keshwananda Bharti is a book on constitutional law, one might say. On the other hand, this judgment is just 3 pages long. For a landmark judgment of the Supreme Court to be just 3 pages long, we are very fortunate indeed, and that is why we should take up reading this judgment in its original. It's quite straightforward, and it is quite crucial in the history of our republic and in the history of the Supreme Court as well, consequently. 9th April 1951 is when the judgment was given by the full bench of the Supreme Court. By now, the Supreme Court had 7 judges, as was prescribed in the Constitution, and all of them sat on the bench which heard this particular case, and all of them unanimously found in favor of the respondent, Champakam Dorairajan. The case was decided on 9th of April 1951. That is right, we are in the second year of our journey and also of our republic. We are in 1951, and this case originated in the state of Madras, filed by Champakam Dorairajan in the Madras High Court. The Madras High Court found in her favor, and so the state of Madras appealed against that Madras High Court judgment in the Supreme Court. That is why, of course, in the Supreme Court it got registered as State of Madras versus Srimati Champakam Dorairajan. The reasons why this is such an important case, it is definitely more important than perhaps some of the other cases we have already looked at. This is at least as important, perhaps more, than the A.K. Gopalan judgment, the first fundamental rights case heard by the Supreme Court. This is once again a fundamental rights case, just like A.K. Gopalan and Romesh Thapar and Brij Bhushan and N.B. Khare, but it has an even deeper impact. The most important thing discussed in this case was regarding the primacy of fundamental rights and directive principles of state policy. Part 3 of our Constitution enumerates the fundamental rights which each citizen and many persons as well, many non-citizens as well, possesses. And Part 4 talks about the directive principles of state policy, policies which the government is encouraged to pursue in order to improve the status, the standard of living, the overall well-being of the population of the country. And the major discussion happening in Champakam Dorairajan was which of these take precedence. Should fundamental rights be above the directive principles as far as any clash between the two is concerned, or should directive principles of state policy hold precedence? Which has primacy? If the government is implementing something recommended in the directive principles, is the government then allowed to infringe a fundamental right in order to implement a directive principle? That is the major discussion over here, and that was a major discussion for the next 30 years at least of our republic. It is also an important case in the context of reservations. This is the first time that a situation involving reservations made its way to the Supreme Court. So it's the first time that the Supreme Court got an opportunity to interpret the law of the land based on the concept of reservations, and it required interpreting Article 15 and Article 29 of the Constitution. And on the downside, the eventual judgment contributed to the passage of the First Amendment. As I have already mentioned, the First Amendment is not, I'm not a big fan of the First Amendment. And if I survive into my 70s, then I intend to start a movement, an andolan, for the repeal of the First Amendment, for its rollback. Much of my stance has been guided by this wonderful book which I have mentioned before, by Dr. Tripurdaman Singh, 16 Stormy Days, the story of the First Amendment to the Constitution of India. Dr. Singh has done extensive research and written in a very lucid and readable fashion. It's a great book even for a layperson, and you really must read that book. I should really insist. Anyway, the First Amendment to the Constitution of the United States, I have mentioned before, expanded the freedom of speech and expression. The First Amendment to the Indian Constitution contracted the freedom of speech and expression, also contracted the right to property, also contracted the right to equality. But there are reasons for that as well. We are well aware of the social history of India, the pre-independence, pre-republic social history, where the caste system, the original sin of our nation, had imposed such cruel treatment of so many people of our country that there were various organizations trying to come up with a solution to that. One such organization was the Justice Party, based out of Madras, the party that later was led by the Periyar Ramaswamy Nayakar, who then converted the Justice Party to the Dravid Kalagam, which eventually became the Dravid Munnetra Kalagam, the DMK, which is, as of today when I'm recording this video, the government ruling the state of Tamil Nadu. Anyway, that is a different political history. The point here is the activities of these organizations. The Justice Party was especially focused on ensuring that the overrepresentation of Brahmins, especially in various government institutes, in various government organizations and departments, needed to be curbed. That was their chief aim. And the problem that they had raised, the issue that they had raised, found a lot of resonance amongst the people. It was quite evident that based on population, the Brahmin community in the country, or even in the province of Madras, was much smaller than the rest of the Hindus. Even we're not even considering Muslims and Christians, etc. Even if you consider just the Hindus of the province of Madras, the Brahmins would have perhaps amounted for somewhere between 5 to 10% at that time of the population of Hindus, and representation in the government organizations was closer to 90%. So trying to normalize this was one of the objectives of the Justice Party movement. Whatever might be the reasons behind this skewed ratio of population and representation, one of them being that Brahmins traditionally seemed to have focused on education, especially during the British time. They took to English education sooner than everybody else, and they ended up therefore monopolizing, as it were, all of the positions available in the government. And to normalize this, there were various solutions presented. One of them was what became the Communal General Order. It was executed in the year 1921 when the provincial government of Madras was dominated by the Justice Party. This Justice Party government came up with the idea of a formula for reservations in government departments as well as admissions for educational institutions. The formula was every set of 13 seats should be divided in this manner. 3 should be for non-Brahman Hindus, 2 should be for Mohammedans, 2 for Anglo-Indians, 2 for Indian Christians, 1 for Brahmins, and 1 for other depressed classes, that is what they were calling backward Hindus at that time. So every set of 13 seats would be divided in this manner. So if there were 26 seats, there would be 10 of those would be for non-Brahmana Hindus and only 2 out of 26 for Brahmins, 4 for Muslims, 4 for Anglo-Christians, Anglo-Indians, and so on and so forth. This was the first instance of reservations, the first instance of this communal general order, or the communal GO as it came to be known. Over the years, the communal GO kept on getting modified slightly, even as governments changed in the province of Madras. And by the time of independence, in the year 1948, the province of Madras was ruled by a Congress government, and that government also had instituted its own version of the communal GO. The premier at that time, Mr. O.P. Ramaswamy Reddyar, his government came up with this version, this formula for reservations in government departments and educational institutions. The formula had now changed to 14 seats instead of 13. Out of every 14 seats, 6 should go to non-Brahman Hindus, 2 to Brahmins, 1 to Muslim, 1 to Anglo-Indians and Christians and Europeans, 2 to others, and 2 to Harijans. So there seems to have been some reshuffle based on population numbers probably, or vote bank politics perhaps, who knows. But this is what it stood at the time of the initiation of our particular case. The reservation, out of every 14 seats, only 2 would be available to Brahmins. So if even if, as it turned out, there were more Brahmins applying than the entire rest of the populace, even then only 2 of them would get through out of every 14 seats, which meant that the marks required for Brahman candidates to get admission would be greater. The qualifications required for Brahman candidates to get a particular post in a government department would be greater compared to the other categories. This is a simple demand-supply kind of a result. It was this situation that was faced by our respondent Champakam Dorairajan, and Dr. Singh, Dr. Tripurdaman Singh, in his book calls this communal GO a sitting duck. A sitting duck as far as the constitution was concerned once it came into force, because Article 15 was quite clearly getting violated by this communal GO. Clause 1 of Article 15 says that the state shall not discriminate against any citizen on the grounds only of religion, race, caste, sex, place of birth, or any of them. Quite clearly, prima facie, the 1948 communal GO and the ones that came before it, but the 1948 one was in force at that time. The 1948 communal GO was quite clearly violating Article 15(1). It was also violating Article 29, Clause 2. No citizen shall be denied admission into any educational institution maintained by the state or receiving aid out of state funds on grounds only of religion, race, caste, sex, language, or any of them. And obviously, educational institutions receiving government aid included the medical college that Mrs. Champakam Dorairajan was trying to secure an admission into. It all kicked off in June 1950, right? 5 months into into the 5th month of our republic, Mrs. Dorairajan, having attempted to be admitted into the Government Medical College Madras, found out that although she had more marks than some of her competitors, they got through while she did not, because they happened to fall within the formula of the 1948 communal GO, while she happened to be a Brahman, and there happened to be at least 2 more Brahmins who had better qualifications than her, and that is why she challenged the communal GO in the Madras High Court. There were people with fewer marks than her who had gotten admission into the Government Medical College Madras, and she, despite having better marks, did not get through. A week after that, when Mr. C.R. Srinivasan, who is not as well known as Champakam Dorairajan because of what the case is known as, Mr. Srinivasan tried to secure admission in the Gwindi Government Engineering College. engineering and medicine right from the 1950s remain the most sought after career choices for our people. And Mr. Srinivasan faced the same issue as Mrs. Dorairajan. He did not get through into the college despite having better marks than many others. Both of them filed under Article 32 and called for the communal GO to be ultra vires as per the articles 15.1, 29.2 and indeed 13.2. The Madras High Court, a three-judge bench in July 1950, did indeed find the communal GO violative of 15.1 and 29.2, and therefore, under the provisions of Article 13, held the communal GO ultra vires. It was violative of the Constitution, and no government authority, neither legislative nor executive, could pass any law which was violative of the Constitution as per Article 13. The government of Madras, stinged by this decision, filed an appeal against it in the Supreme Court, and that is how this case came into being. As a sidebar, if I may, a similar suit was filed directly into the Supreme Court by Advocate B. Venkataraman. Advocate Venkataraman had been practicing in Nellore for 7 years already. He had degrees in mathematics and law, and he was well qualified for the post of the district munsif in the Madras Subordinate Civil Judicial Service. But he faced the same issue. While Champakam, Dorairajan and Mr. Srinivasan, both of them had attempted to get into educational institutions, Advocate Venkatraman had attempted to get into government service. Both these fields were governed by the same communal GO, and all three of these individuals faced the same issue. They had better qualifications than many others who did get through, and that is why they claimed that their right to equality was being violated, and Articles 15 and 29 were being violated by that communal GO. All of this then came before the Supreme Court and was decided in the state of Madras versus Champakam Dorairajan. We will discuss the details about the arguments made, etc., and the decision made by the Supreme Court and its impact in the upcoming videos. Hope you join me then, and hope you are enjoying these videos. Thanks for all the support. See you again soon. Bye bye.